Welcome to Law Family. This video is helpful to the law students and newly practicing young advocates only. Today, we discuss about the distinction between Section 17 of BNS Act. Corresponding law is 79 of IPC and Section 151 of BNSS Act 2023. Corresponding law is Section 132 of CRPC. Section 17 of BNS Act can only be applied when all the facts are known, that is, when the trial is over, whereas Section 151 of BNSS Act 2023 can only operate before the trial begins. Important point. The protection given by Section 17 of BNS Act is a protection against conviction, while the protection given by Section 151 of BNSS Act 2023 is a protection against trial.
Welcome. Mistake of fact and mistake of law. Mistake of fact relates to a misunderstanding of factual circumstances. Mistake of law relates to a misunderstanding of the legal rules or principles. In criminal cases, mistake of fact is more accepted defense than mistake of law. A valid mistake of fact can be a complete defense, meaning the person is not guilty of the crime. This is good faith, important point. The mistake must be made in good faith, that is genuinely believed to be true and not be due to negligence or recklessness. Mistake of law versus ignorance of law. Ignorance of law is generally not a valid defense, which mistake of law may be defense in very limited circumstances. Important point on ignorance of law. Individuals are presumed to know the law and cannot use their lack of knowledge as a defense in legal proceedings. Important. Ignorance of statute newly passed. This is explanation. A person commits an act which is made an offense for the first time by a statute so recently passed as to render it impossible that any notice of the passing of the statute could have reached the place where the offense has been committed. Yet his ignorance of the statute will not save him from punishment. A mistake of fact consists in an unconsciousness, ignorance, or forgetfulness of a fact, past or present, material to the transaction, or in the belief of the present existence of a thing natural to the transaction which does not exist, or in the past existence of a thing which has not existed. Mistake must be one of the fact and not of law. Again repeat. Mistake must be one of fact and not of law.
Mistake of fact. Good defense. The accused, a police constable, saw the complainant carrying his arm 3 pieces of cloth. Suspecting that the cloth was stolen, he went up to the complainant and questioned him. He went up to the complainant and questioned him. The complainant gave answers but not satisfactory. and he was arrested by the constable but was released by the constable but was sorry but was released by the inspector of police. The complainant then prosecuted the constable for wrongful restraint and consequent confinement, and the magistrate convicted the constable of the said offence. The High Court held that the conviction was wrong as the constable acted under a bona fide benefit, that he was legally justified in determining what he suspected to be stolen property. He was protected by this section.
Mistake of fact, bad defense. Intoxicating liquors as were sold or delivered in corked and sealed vessels in the prescribed manner, and a licensee delivered liquor to a child under 14 years old, it means the vessel of liquor either corked or sealed or not corked and sealed. It was held that he was liable under the statute, although the honesty believed when he delivered the liquor that the vessel was so sealed and corked.
Ignorance implies passiveness. Mistake implied action. Ignorance does not pretend to knowledge, but mistake assumes to know. Ignorance may be result of laches, which is criminal. Mistake argues diligence, which is commendable. Ignorance of law does not excuse a person who does an action which is an offence, irrespective of any guilty knowledge on the part of alleged offender. Absence of the knowledge remained to constitute the offence proceeded from ignorance of law or ignorance of fact. Ignorance of law is no ground of defense. It is evidence of mental condition. Punishment.
Punishment section. Matter to be taken into consideration in mitigation of punishment. This video is purely theory. The Honorable Court decides each case on merits.
Thank you.